Good afternoon, everybody, and welcome to Sky's Deprivation of Liberty webinar. My name is Hugh Constant. I'm a Practice Development Manager here at Sky, and over the next hour we're going to discuss deprivations of liberty generally and the deprivation of liberty safeguards, which only apply in care homes and hospitals, of course, more particularly. Deprivations of liberty, I think it's fair to say, have been very high profile over the last couple of years. And I suppose the message of today's webinar will be that for all the problems that the system is facing at the moment, they remain a very important safeguard for vulnerable people. And hopefully that message will come across. So by the end of our time together, I'm hoping that you'll have a sense of when and how a deprivation of liberty might be occurring and what to do about it if it is. There are, I believe, about 100 of you listening, and you will no doubt have a wide range of experiences working with deprivations of liberty and come from a wide range of backgrounds. So what would be absolutely fab, therefore, is if you kind of share that learning and share that knowledge and ask each other questions. And all of that can be done via the chat box, which hopefully you will be seeing on the bottom right-hand corner of your screen. So do ask us questions, ask each other questions, and make this as interactive as you can. We will not be able to answer every question that you ask, but my colleague Helen is here, and she will be picking up on sort of key questions and recurring themes. And a couple of times during the webinar, we're going to sort of pause for 5 minutes, and Helen's going to put to me some of those key issues that she's picked up on. Okay. And we will also be sharing at the after the webinar a full transcript of the chat box. So as well as you seeing how many times people have said, "But I can't hear him," or the technical glitches that there are, you will get a sense of what other people are thinking about and what people are talking about. If there are any IT glitches, we do have IT experts here as well, but what we can do at this short notice might be quite limited. But hopefully the technology is working well for as many of you as possible. You can, I hope, hear me. We won't at any point in the webinar be able to hear you, so don't try and use your microphones to ask questions. Make sure you ask anything through the chat box, okay? So in a minute we're going to switch to some slides, and you will start seeing my face and see the slides instead. And from then on there's going to be a mixture of slides. There's going to be some quiz questions, and dotted through the webinar there are going to be some polls where I'm going to ask you your opinion on deprivations of liberty and some of the key issues, and also a couple of points where I'm going to ask you to sort of go away and think about, you know, your practice and how that can be improved and developed in the area of deprivations of liberty. Okay, so if that all sounds okay, we're going to switch now to the slides, and we'll take it from there. Okay, so yes, as I've said, this is deprivations of liberty, an introduction. So this will be a kind of overview of the topics. But before we get into the detail of what we're going to cover, I just want you to have a read of this quote, okay? This is a quote from Eleanor Roosevelt, wife of the former US President Franklin Roosevelt. And I think it's important because if in your work you are ensuring that a person with dementia in a care home, or a person with learning disability and supported living, or whatever it is, whatever your work setting is, if you're making sure that they are not unlawfully deprived of their liberty, then you are protecting and promoting human rights just as much as any person working for Amnesty International, or just as much as any, you know, hotshot human rights lawyer. And that will mean the world to the individual people that you're supporting. And that's why I think the Mental Capacity Act generally and deprivation of liberty safeguards in particular, you know, why they are so important, okay? So this is what we're going to spend the next hour covering. I hope this is more or less what you were hoping for. If there's anything on there that you were burning to know about and isn't on there, then you know, stick that question in the chat box and we'll do our best to answer it. But we're going to look at the links between deprivations of liberty and human rights legislation and the Mental Capacity Act. and then look at the deprivation of liberty safeguards themselves, where they came from and what the safeguards are. Then we'll look at how you go about authorising a deprivation of liberty where you think one might be occurring, be that in a care home and hospital, where there is one way of doing it, or in the community where, as you may know, there is another way of getting the deprivation approved. We'll then go on to look at the Cheshire West and Surrey judgment, the Supreme Court judgment that introduced this notion of the acid test around deprivations of liberty and referred to gilded cage as still a cage, and the huge impact that that has had and what that means for the deprivation of liberty system as it currently stands. We'll touch briefly on the links between deprivations of liberty and the Mental Health Act, when you use the deprivation of liberty safeguards, when you use the Mental Health Act. And then we'll finish off looking at deprivations for children, because that's been very much in the news recently. And then finish with looking at what this might look like in the future, because as you will probably know, this is a system creaking under its own weight, and a new regime needs to be introduced. Okay, so if that looks all right as a way to spend the next hour, we will crack on. And I'm going to try our first poll at this point, okay, just to get you into the habit of using them and just to see what you guys think about the deprivation of liberty safeguards in particular. So there are your options. Are the deprivation of liberty safeguards an important protection of vulnerable people's human rights? A massive bureaucratic headache? Neither of the above, or both of the above? And we are hoping that that is viewable on your screen, but it looks a bit weird at the moment. Can people see that? Okay, no, so you clearly can. I have to say that is commendably positive of you all to, well, of 2/3 of you precisely, to view it primarily, because these are clearly an important protection of people's human rights. I think those of you that have voted for both of the above, I think can be, I well understand your position, because that they have now become a bureaucratic headache, undoubtedly. And I think that the important message is that we don't lose sight of the protection that they offer people when we are filling out yet another form or waiting yet again for a local authority to come back with an authorization or not. So yeah, that's brilliant. That's how the polls work. And I think, yeah, as you say, that these are important protections, albeit ones that are currently, needing to work a fair bit better. Okay. Now, for all the negativity that might be surrounding the deprivation of liberty safeguards, everyone remains, on the whole, I think, hugely positive about the Mental Capacity Act. Everyone loves the Mental Capacity Act, and it is worth reminding ourselves, of course, that the deprivation of liberty safeguards, although they were introduced 2 years later, are part of the Mental Capacity Act. And so, very briefly, I just remind you, I guess, of the 5 statutory principles. Of course, the whole question of a deprivation of liberty only occurs when someone lacks mental capacity, and so of the 5 statutory principles, only numbers 4 and 5 really apply, because those, of course, are the ones that kick in when someone is known to lack capacity. So any deprivation of liberty, therefore, has to be in a person's best interests. We know that, and also one of the key safeguards is that there are people checking to make sure that if someone is deprived of their liberty, that is done in a way that is as least restrictive of their rights and freedom as possible. So the deprivations are absolutely grounded in the Mental Capacity Act in all its glory. And because they're rooted in the Mental Capacity Act, they are also therefore rooted in human rights legislation. Now, our human rights legislative framework in this country is basically shaped by the European Convention on Human Rights, which the UK signed up to in 1950, and which then passed directly into British law in 1998 in the form of the Human Rights Act. And so when we talk about deprivations of liberty, we are essentially talking about Article 5 of the European Convention on Human Rights. And what that says is spelled out here, that everyone has the right to liberty and no one shall be deprived of his liberty save in accordance with a procedure prescribed by law. And what it then goes on to say is that anyone who is deprived of his liberty shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court. Basically, what that means is that if someone is going to deprive you of your liberty, then there needs to be a legal basis for that. Typically, that would be the courts locking you up if you're particularly naughty, or under the Mental Health Act, you can be sectioned. But again, that is a procedure prescribed by law. And crucially, in both those cases, you have the right to appeal, and the lawfulness of that detention can be challenged and decided upon in the courts. Okay. And it is worth noting the language there for a moment. The language of deprivation of liberty sounds awful. No one in a care home wants to think that they're depriving someone of their liberty. That sounds particularly harsh and brutal if you're providing loving and supportive care to a frail elderly person or whatever. And it seems a ridiculous expression to apply to an intensive care unit. But this is why we have the language deprivation of liberty, because it is a language lifted directly from the European Convention on Human Rights. And as we'll see at the end of the webinar, the language in the future will be softened considerably, so that we're not put off by the harshness of that term deprivation. But anyway, that's Article 5 of the European Convention, and it was that article that the British government was found to be in breach of in the case, in what is known as the Bournemouth case, which created this notion of the Bournemouth gap. The Bournemouth case revolved around a young man with learning disabilities and autism known by the initials HL. And HL had challenging behaviour and was exhibiting that challenging behaviour one day in his day centre to such a degree that he was taken from the day centre and taken to Bournemouth Hospital, which was a secure unit where he was kept for some considerable time. And he lacked the capacity to consent to his detention in the hospital. That was well beyond his cognitive capacity. And so there he was, deprived of his liberty without having consented to it. And the carer said, well, his carer said, well, on what basis have you done this? On what legal basis have you essentially locked him up, given that he can't consent to it? And the answer was essentially that there was no legal basis for his detention, and this gap in the law became known as the Bournemouth gap. And it was the Bournemouth gap that the Deprivation of Liberty safeguards were set up to fill, basically, because we were left with a system in British law where a whole bunch of people with autism, people with dementia, whatever it was, were being deprived of their liberty. They hadn't consented to it, but there had been no procedure prescribed by law in the language of the convention that allowed that person to be deprived of their liberty. And so the Deprivation of Liberty safeguards were then brought introduced in law in 2007 and introduced in practice in 2009 to plug the Bournemouth gap. Okay. So what the Deprivation of Liberty safeguards give us then is the procedure prescribed in law when it's necessary to deprive someone of their liberty in order to keep them safe from harm where they lack the capacity to consent to that, basically. And it is worth stressing that point, in order to keep people safe from harm. Going back to the point about how harsh the language sounds, depriving someone of their liberty, if it is to keep them safe, is a good thing. And however much the language might make us think that it's something that needs to be avoided at all costs. We shouldn't be depriving people, willy-nilly without good reason. But if it is in their best interests and it is proportionate to keep them safe from harm, then clearly it becomes the right thing to do. If you have a home for people with dementia who, some of whom would wander out of the door and into a road of busy traffic, it is, it feels self-evidently the right thing to lock the front door. So depriving someone of their liberty, not inherently a bad thing, but there needs to be safeguards so that people are not deprived, without good reason. Okay. So The safeguards are various, and basically that they are a series of measures put in place to make sure that people can appeal and they can be supported to make those appeals. So if a person has no family or friends who can support them with the process, then they have the right to an independent mental capacity advocate to help them with the process. Anyone deprived of their liberty under the safeguards is called the relevant person in the language of the safeguards, and they are entitled to a relevant person's representative to, again, support them with the process. This will typically be a family member or a friend, but may, if the person doesn't have family or friends, the local authority concerned with the person has a duty to identify a paid relevant person's representative. And that representative can support them to make appeals and can help them challenge their deprivation. Okay? Also, people who are deprived of their liberty might have a lasting power of attorney, might have given a loved one a lasting power of attorney. And while an LPA can't in themselves authorise a deprivation, they can have a say in what conditions might be attached to a deprivation, who the relevant person's representative is, and so on. Okay? But crucially, all these supports are there to support a person if they want to appeal. Going back to that notion, to the European Convention of Human Rights, everyone has a right to have their deprivation challenged, and so one of the key safeguard in the deprivation of liberty safeguards is this right to appeal, and that might be to the supervisory body, the local authority that that is concerned with the person, or if need be to the Court of Protection itself. And we'll look at that in a little more detail later. Okay. Now, ever since the deprivation of liberty safeguards were introduced, the question everyone asked, I was a social work manager at the time, and I asked it was, well, what actually does a deprivation of liberty look like? Is it, cot sides on a bed? Is it a keypad on a front door? Is it more serious than that? And the answer was that well, it was never essentially very clearly defined. Other than these three elements, which are known as the stalk elements, and despite the graphic, the stalk element has got nothing to do with the bird. Stork was a young German girl who was the subject of a European court case about deprivation of liberty, and that case gave us the stalk elements. And there are three. The first one is what is known as the objective element, which is that the person has to be confined in a particular place for a not negligible length of time. I've been practicing saying not negligible a lot because it doesn't trip off the tongue very easily. But that is the objective element. Basically, is someone in a place for a reasonable period of time, that amounts to a deprivation of their liberty. The second element is the subjective element, that the person hasn't consented to it. So to remind ourselves, if someone has capacity to consent to what's going on, then deprivation of liberty questions simply don't apply. Okay. So the subjective element is that the person hasn't consented, and in British law they have to be unable to consent because of a disorder or disability of the mind as set out in section 1 of the Mental Health Act. Okay. And the third stalk element is that the deprivation or the detention has to be imputable to the state. And what that means is that the state is responsible for the detention. Now, if someone's care in a care home is paid for by the local authority and the care home is owned by the local authority, then it's very clear that their deprivation is imputable to the state, is the responsibility of the state. But it is worth being absolutely clear that if, for example, a self-funder is paying for themselves in a care home and the local authority has had no part whatsoever in the organisation of that care, that still remains imputable to the state, because that care home is subject to monitoring by CQC and is subject to a whole range of state legislation and state scrutiny. So basically, pretty much everyone's deprivation is imputable to the state. The only situation where it might not be is if someone is deprived of their liberty in their own home by their own family, so maybe an elderly parent is kind of locked in a house or whatever, or there were locks put on certain parts of the house by their son or daughter, and the state has no way of knowing that that's happening. But basically, in any care setting whatsoever, the care will be imputable to the state. Okay, so those are the three elements that need to exist for there to be a deprivation of liberty. So that much hopefully is clear, but there is still uncertainty around some of this and plenty of room for debate. So the objective element, for example, confinement in a particular place for a not negligible length of time, huge amount of discussion is given over to this notion of what constitutes a not negligible length of time. And that's what I want you to answer now in the next poll, okay? What would you consider to be a not negligible length of time to be depriving someone of their liberty? Would it be an hour, 24 hours, 2 to 3 days, 7 days? What do you reckon? Hopefully people can see that. My colleague here is broadening it out so that you can. "24 hours is gaining." Okay. So, Rebecca, I can see that you don't get the question. But the question is, how long do you think someone could be deprived of their liberty without needing it to be authorised in, by using the deprivation of liberty safeguards or anything, because the amount of time is so short? So, if someone were only deprived of their liberty for an hour, would that constitute a not negligible length of time? I might have made it even more confusing there. Sorry, Rebecca. But basically, I mean, what we can see is that about half of you think that an hour would constitute not negligible, and about a third of you 24 hours. And it's really interesting because particularly as the kind of the whole system grinds to a halt under the weight of all the applications, care providers, be they care homes or hospitals or whatever, are trying to argue that a longer and longer period of time is okay to keep someone without getting the deprivations authorised. And basically, I think they are on fairly dodgy ground if they think that. And it's not very clear, but in the top right-hand corner of this slide, there is a graphic of a publication called "Identifying a Deprivation of Liberty: A Practical Guide," which is a publication from the Law Society, which I heartily recommend you read if you work in a care setting, because it is a very helpful guidance on what constitutes a deprivation. But their view, and this is the Law Society, so they're terribly clever and they know what they're talking about, is that you are on very dodgy ground if you think that you can deprive someone of their liberty for more than 2 or 3 days and still claim that that amounts to a negligible length of time, and that you are on really dodgy ground if, as some organisations are arguing, do you think you can last up to 7 days? Because what we've seen is that hospitals and respite homes in particular, where people might be expected to stay for less than 7 days, are saying, well, that's a negligible length of time, so we're not going to bother with the paperwork. And the very clear guidance from the Law Society is that that leaves you liable to legal challenge. I mean, in fact, actually, depending on the situation and depending on the severity of the deprivation, sometimes deprivations of liberty of less than an hour have been deemed to be a not negligible length of time. There was a famous court case of a guy with autism who was behaving in a public swimming pool in a way that was actually fine, but frightened the owner of the swimming pool a bit, and they called the police, and the police locked him in the back of their van for 40 minutes, and they were successfully challenged in court because the intensity of the deprivation, he was locked in a police van, was so intense that 40 minutes deprivation was held to be a not negligible length of time. So basically, it depends on the severity of the deprivation, but you are very unlikely to get beyond about 3 days on that judgment. Okay. Okay, so if you think a deprivation of liberty might be occurring, if you think the stalk elements are met, the confinement in a particular place that someone can't consent to, that is imputable to the state, if you think that's occurring, then you are going to need to get this deprivation of liberty authorised. Otherwise, essentially, someone is locked up illegally. Okay, and we're going to look now at how you go about authorising that in a care home or hospital. That hopefully is a suitably representative graphic of a care home and a hospital. Okay, and in a care home and hospital, of course, is where the deprivation of liberty safeguards themselves apply. We'll come on next to authorising a deprivation in the community. Okay. But in a care home or hospital, there are essentially two forms of authorisation that you can seek under the safeguards. The first one is a standard authorisation, whereby the hospital or care home, which in the language of DOLS is called the managing authority, requests permission, ideally in advance, to deprive a person of their liberty. And they request that permission from the supervisory body, which is DOLS language for the local authority. And the supervisory body then commissions assessments from the best interest assessor and the mental health assessor, as we'll see, to either grant or refuse that application within 21 days of receiving that application. And now, because your microphones aren't switched on, I can't hear you scoff and swear loudly at the idea that local authorities are getting around to doing this in 21 days. As we'll see, sometimes it's taking up to a year for them to get around to do it at the moment, but that is the product of the broken system. They are supposed to do it within 21 days. Okay. In an emergency, the managing authority can give itself authority to deprive a person of their liberty, but only up to 7 days, with one 7-day extension if they want. And this is for when someone moves into a hospital in an emergency or into a care home in an emergency and they don't have time to make the standard application. It is not there, as some people try and use it, to get round doing the standard authorization. So if someone comes into a hospital and they know they're going to be out within 3 days, some hospitals are trying to just give themselves an urgent authorization and hope that will do. It's not instead of a standard authorization, it's as well as, because if you give yourself an urgent authorization, you have to at the same time apply for a standard authorization. Okay, I hope that's clear. So basically, whatever happens, the managing authority has to apply to the supervisory body for a standard authorization, whether or not you've done an urgent one in the meantime. And this is what a standard authorization, this is what the process looks like, sort of. The authorization process is made up of 6 assessments, some easier to carry out than others. The first one is an age assessment, okay, where basically you have to check whether the person is 18 or above. If someone is deprived of their liberty and they're 16 or 17, you have to go to the Court of Protection. We'll come on to that. So first assessment is the age assessment. Now, that can be carried out either by the best interest assessor or the mental health assessor, who is a Section 12 doctor. And we'll, as we go through them, I'll tell you who has to do each one. That one can be done by either. As can the second one, which is called the no refusals assessment, which is just checking that there is no legal process already in place, like a court-appointed deputy or a lasting power of attorney, where that they are saying that moving into that care home is not in the person's best interests, or whatever it is. There might be an advanced decision that would block anything that blocks the deprivation of liberty. So either the best interest assessor or the mental health assessor can carry that one out. Then, as we've said, this only applies if someone lacks capacity to make a decision. So someone needs to do the standard capacity assessment. Can the person understand, retain, weigh the information and communicate a decision? And if they can't, then they lack the capacity to make that, to make the decision about where they're accommodated. Now, the fourth one is the mental health assessment, whereby, and this can only be done by the mental health assessor, who has to be a Section 12 doctor. What that means is that they are registered under Section 12 of the Mental Health Act to be suitably qualified to judge whether someone has a mental disorder within the meaning of the Mental Health Act 1983. And that needs to be in place before someone can be deprived of their liberty. Okay. The fifth one is that is checking whether the Mental Health Act should be used instead, and that can be carried out by the Section 12 doctor or the best interest assessor, providing the best interest assessor is also an approved mental health practitioner. This is complicated stuff. Happily, unless you're working for the local authority, it's not you that has to sort this out. It will be the best interest assessor. And then the final test, the final assessment is the key one, really, that can only be carried out by the best interest assessor, and that is the best interest assessment, where the best interest assessor needs to judge whether a deprivation of liberty is occurring, and if so, whether it is in the person's best interests, and it's there to prevent harm to the person, and it's proportionate to that harm. Okay, and that is essentially the key test. Is the person being deprived of their liberty, and if so, is it the right thing to do? Is it in their best interests? And basically, if all 6 boxes are ticked, then you get your standard authorization. Okay, so it is not a straightforward process. It's a fairly complicated process, and as we'll see, the numbers of requests for these are going through the roof so much that local authorities are hugely struggling to train enough best interest assessors and enough good quality best interest assessors to make sure that these are done properly. But that basically is the process that needs to be gone through for a deprivation to be authorised. And that deprivation stays in place for a maximum of a year, and it can't just be rubber stamped that it carries on after that. The whole process has to be gone through again because it's too important a process to just rubber stamp. All the assessments need to be done again. It can apply for less than a year. The best interest assessor can attach various conditions to an authorization. So they might, for example, go through all that and say, yes, okay, we authorize the deprivation, but we're going to attach the condition that whilst this deprivation is in the person's best interest, it will only be in their best interest providing that they always get to church on a Sunday morning, because that is hugely important to them. So it's okay to lock the door, and it's and we understand that staff aren't always going to be available to take them out whenever they want, but they do need to be staff available to take them to church on a Sunday morning. So the best interest assessor has quite a lot of powers to set conditions. So, and one thing that they often do, and often to meet the least restrictive requirement that the MCO asks of us, is that the authorization is sometimes for less than a year. But for however long it is, it will come to an end at some point, either when the person leaves, regains capacity, or sadly deprivation has ended. Okay. Now we're just going to go through authorising a deprivation of liberty in the community, so in supported living, shared lives, for example, and then we're going to pause for a couple of minutes for questions. Okay. So community deprivations have similarities and differences. The same considerations apply. The stalk elements need to be there. Someone needs to be confined in a particular place for a non-negligible length of time. They need to not be able to consent, and it needs to be imputable to the state. Yeah. But if that applies in a shared life scheme or a supported living scheme or whatever it is, then the application is to the Court of Protection, not the local authority. Okay. Now, if you work for a provider, you do have a duty to tell the local authority if you think a deprivation is occurring. It is the local authority who has the obligation to apply to the court. I'm hearing about a lot of local authorities who are trying to pass that duty back to the providers. Providers can apply to the Court of Protection if they want, but it is the local authority who has the positive duty to do it. Now, community deprivations can technically apply in people's own homes and day centres, but authorisation for that, particularly in day centres, is vanishingly rare. And I think whilst there is acknowledgement that people can be deprived of their liberty in their own home and in a day centre, there is really no will, there is no enthusiasm for burdening the Court of Protection with yet more applications, because as we'll see, they are struggling post the Supreme Court judgment. So I think at the moment that those situations should be kept an eye on, and people should be doing all they can to minimise restraint and deprivations in those settings, but getting them formally authorised doesn't seem to be required particularly. Okay. And with that, as I say, we're going to pause now for a couple of minutes, and Helen is going to ask me questions, and I will do my best to answer them or point you to somewhere where you could find the answers.
Okay, so just first of all, relating to the slide you had up a moment ago on ending authorisation. Becky asked, if a person is subject to a deprivation of liberty in hospital, do they need a separate one for hospital transport to a residential home?
I mean, I think it would depend on the question of not negligible length of time. Probably you will get situations where technically, yes, someone would be deprived of their liberty, and that technically it would therefore be the proper thing to do to apply for to apply for an authorization. I do think that and I really don't want to give the message that we need to water down these safeguards, but I think if someone is going in standard transport from care home, from hospital to care home, and that is a sort of half an hour drive or whatever, I don't think anyone is ever going to get close to looking through the paperwork to approve that deprivation. Where I think you might need to pay more attention to it is if someone is going to a very specialist unit, and this applies in sort of mental health cases, for example, where the right setting might be at the other end of the country. If someone is going to be in an ambulance for a sort of 3 or 4 hour drive, then I think you probably would need to. I mean, in essence, I think that the best thing to do would be to contact the DOLS team in the relevant local authority and say, look, this is the situation, what do you want me to do? But yes, I think in most settings, a straightforward trip from hospital to care home, people aren't going to be pushing too hard for a separate DOLS application.
Great. And another query we had is where does one-to-one support fall if the person is deemed to lack capacity and is in a general ward?
I mean, I think if someone is a general ward, I mean, we'll come on to the acid test in a minute when we've finished with these questions, and we will see, as most of you probably know, that the acid test is a question of continuous supervision and not free to leave. And I think that someone in a general ward would probably not be free to leave, and if they had one-to-one support, that would probably fall under continuous supervision. But we'll discuss that more in a minute, I think.
And also, just so Julie and others know, so we will include in the webinar, when we publish it online, links to the Law Society guide, as well as areas of the MCA directory on the Sky website, where you can read about different case law as well. But Terry was just going to ask about the Supreme Court ruling that said the deprivation of liberty safeguards now apply to 16 and 17-year-olds.
Terry, I'm sorry you don't have sound. We're going to get on to 16 and 17-year-olds. The deprivation of liberty safeguards still only apply at 18 and above. Well, what the Supreme Court ruling has stated, as I understand, my reading of it is that this means that you might need to get more deprivations of liberty authorised by the Court of Protection. But as I say, we'll come on to that towards the end of the webinar about that latest judgment and how that applies to children and their deprivation. Okay.
And Maria's question is, do these procedures apply to Northern Ireland, or is there separate guidance that should apply to that?
These don't apply to Northern Ireland, and we'll have to look out separate guidance for that. And whoever's typing as guest, that is a very good point, that I have just given a spoken answer to someone who's just told me that they don't have any sound. That was a waste of time for him. We'll try and make sure that we get that message to Terry somehow. Thank you. I think if that's okay for now, then we will move on. So we've sort of covered how that deprivation of liberty might need to be authorised, and kind of how the deprivation of liberty safeguards first came about. And I think that there was a general consensus building that the authorisation process was too complicated, and that it was nonsensical, really, that different rules applied in different settings. So, you know, a deprivation in a care home would require going to a supervisory body, whereas a deprivation in a supported living scheme that might look very similar in terms of the care regime would have to go to the Court of Protection. So there were grumblings about the deprivation of liberty system anyway, and then we came to the fateful day, I suppose, of Wednesday the 19th of March 2014, a day that sort of blew the whole thing out of the water to some extent, because this was the day of the Supreme Court judgment on the Cheshire West and Surrey case. One young man in Cheshire West and two young sisters in Surrey County Council, and their care regime was taken to the Supreme Court with the purpose, essentially, to define the objective element of the stalk requirement, to answer the question, okay, so what is confinement for a non-negligible length of time? What does that mean? What does a deprivation of liberty actually look like? Is it just a keypad? Is it, you know, does it require 24-hour monitoring from a member of staff, and so on? And it's worth remembering that actually the judgment on this was very split, particularly in the case of the two young women in Surrey, but the majority verdict, as written up and reported by Lady Hale, there she is in all her finery, was that was such as created this notion that we're probably now all familiar with, of the acid test. And she said that for someone, that a deprivation of liberty was occurring if someone was under continuous supervision and they were not free to leave. Now, that judgment, but by saying that continuous supervision, not free to leave, amounted to a deprivation of liberty, that significantly lowered the bar from what people had been used to and what people's day-to-day practice was. And it was that lowering of the bar that has caused such a sort of headache in the system. But it is worth pausing to remember, actually, that it is very good now that we have clarity. That's why the cases were taken to court, because we wanted clarity in the system, and we at least now have it. But also, the judgment sent, I think, a very powerful and very important human rights message. And it's worth dwelling on that a bit, okay? And these were the words with which Lady Hale gave this message about the universality of human rights, okay? And what she said is this, that if it would be a deprivation of my liberty to be obliged to live in a particular place, subject to constant monitoring and control, only allowed out with close supervision and unable to move away without permission, then it must also be a deprivation of the liberty of a disabled person. The fact that living arrangements are comfortable and indeed make my life as enjoyable as it could possibly be should make no difference. A gilded cage is still a cage. And I think what she's saying, and it is as I say, a hugely important message for, you know, the equality of people with disabilities, people with dementia, and so on, is that we should not be comparing people's lives with the lives of other disabled people when we judge whether their human rights are being sort of curtailed or not. We should judge them against the lives that everyone else in the society lives, because, you know, disabled people have just the same human rights as we all do. And she's quite right, of course. If any of you listening to this were subject to some of the regimes in, you know, in even the most benign and supportive care home or supported living setting, we would feel that we were being deprived of that liberty. And if we are, then so are disabled people. And that's the key message of the Supreme Court judgment that I think it very understandably sometimes get lost in all the paperwork that it's created. Okay. And although it brought a huge measure of clarity, Lady Hale's judgment, you know, there were still debates to be had. What does she mean by continuous supervision? What does she mean by being free to leave? And it is worth reflecting that continuous supervision does not have to be 24-hour observation by an individual. So telecare could amount to continuous supervision. An alarm pad on a door that alerts someone to the fact that someone has left the building and someone then goes and brings them back, that constitutes continuous supervision, as does sleeping staff and so on. And the notion of free to leave can be a little tricky. It's not about an ability to leave, because just because someone is very happy there in a particular place, it doesn't mean that they've got the capacity to consent to be there. So if someone's very happy and isn't trying to leave, that's not the point. The point is, and the question that's worth asking yourself, is if they got up and tried to leave, or if their family came and said, we're taking them away, would you, as the staff member, do anything to stop them? And in virtually all cases, the answer is probably, well, yes, you would, because if you're in a hospital and someone comes to take that person out of the hospital, you're going to say, hang on, they're not free to go because they're here for treatment. If someone is vulnerable enough and lacks capacity in a care home and they say, I'm off and I'm never coming back, you are going to do something about that. So you can begin to see that actually in most care homes and in most hospitals, pretty much everyone is under continuous supervision, and not very many people are actually free to leave. Okay. And so the impact of this lowering of the bar has been absolutely monumental. Very quickly we were operating at a kind of 12-fold increase in the amount of applications for authorising a deprivation of liberty than existed before. So in essence, local authorities were getting as many applications per month as they had been used to getting every year, and this has clogged up the system to a considerable degree with all the problems that we now know about. Okay, and it is that impact of the Supreme Court judgment that has left us in need, in urgent need, some would say, of a new system around deprivation of liberty, and we'll come on to that. But before we do, I just want to pause briefly and get you to think, and I mean, if you want to share any thoughts you have on this in the chat box, please do, but this is mainly just for you to go away and think about yourselves. I mean, and I've virtually just said this, it's commonplace now to assume that everyone is always going to be deprived of their liberty, but in some settings in particular, I don't think that is necessarily the case. And we have a duty under the Mental Capacity Act to be as least restrictive as we possibly can. And it's just worth thinking about, you know, in the care plans that you're devising and in the support that you're offering, are there steps you can take to make sure that someone isn't actually deprived of their liberty, you know, doesn't meet that acid test of being under continuous supervision. Okay. So just something to think about, because it isn't always the case where we just have to throw up our hands and say, well, okay, everyone's deprived of their liberty if they lack capacity. Yeah. There might be steps that you can take. Once you ponder that, I'm going to read to you a case study, and then I'm going to ask you to vote on the answer. Okay, so get your polling fingers ready. So Mr. Ali is 88 and lives in a care home where he has his own room, and he spends most of his time there listening to music and reading, although he does have his meals in the dining room. And he has a daily routine. He leaves the home every morning for a walk after breakfast, and typically he buys a paper and comes back before lunch, but sometimes he eats in a local cafe and returns in the early afternoon. If he doesn't return in the early afternoon, by mid-afternoon, the staff contact the police to take steps to locate and return him. Okay, so I'm going to go to the poll now. Is Mr. Ali deprived of his liberty? And I want you to think about the stalk elements. Is he, and to think about the acid test. Is he under continuous supervision? Is he free to leave? My colleague is going to bring up the poll for you. So you have three choices. Yes, he's deprived of his liberty. No, he isn't. Or we need more information. I can't at the moment see how many people are voting for. We need more information. Well, presumably it's all of you minus. There we go. Well, I think that's spot on. Does anyone want to type in the chat box what more information we need? Oh, multiple attendees are typing. That's great. Becky, you're the first one in with the correct answer. Assessment of capacity, yes, indeed. There is also, I think, yeah, Julie, I think that's key as well. How long before they contact the police? I think there is a question here about if we go back to the scenario. There is a question about whether that constitutes continuous supervision, because he is away from the place for several hours every day. So I think you might have a debate about whether he's under continuous supervision. But what absolutely you need to know, and isn't in that message, is whether he has the capacity. Because of course, if he has capacity to consent, none of this applies. The subjective requirement of the Stork test isn't met. Okay, so yeah, spot on to those that said we need more information. Okay, some slightly strange things have happened to the screen, but hopefully you can still see the slides. That's the main bit. Okay. Now, Deprivation of Liberty and the Mental Health Act do sometimes bump up against each other. Nothing in the Mental Capacity Act, so that includes DOLS, allows for treatment. Sorry, the Deprivation of Liberty safeguards don't allow for treatment. It is just a safeguard that supports someone if they're not able to consent to where they live, not about what treatment that they get. So if someone is detained under the Mental Health Act, or if they're objecting to any treatment that they're receiving, then Deprivation of Liberty safeguards can't be used, and you need to be using the Mental Health Act. Okay, but there are situations where a DOLS authorisation might sit alongside the Mental Health Act, and basically these are situations where someone is under a part of the Mental Health Act whereby they are not detained in a secure unit. So, you know, they're not under a Section 2 or Section 3, for example. So, for example, that might be that they're on a Mental Health Act detention but are on a leave of absence and might, you know, be spending that leave of absence in a bail hospital or a sort of relatively secure setting. You might need to apply for under DOLS for that, or if they're subject to community treatment or guardianship, conditional discharge, those sorts of elements where people are in the community but under a Mental Health Act regime, you might also need to apply for Deprivation of Liberty safeguards. And there was a famous bit of case law that established that if someone is detained for their mental disorder, that needs to come under the Mental Health Act. But if they then need to go to hospital for treatment for a physical condition, because people, you know, can obviously have both, you know, psychosis and diabetes, for example, at the same time, then the detention for treatment for a physical condition would need to be authorised under Deprivation of Liberty safeguards. So yes, the overlap between the two can sometimes be complicated, but hopefully that gives you a sort of rough steer as to when the two do sit alongside each other. But if you're unsure, then I would speak to the DOLS lead in the local authority for further guidance on that. Okay. Deprivations of liberty can occur for children, and there has been a recent case where that has clarified the position on this, and this is the case of D, who the case first went to court last year when he was 15 and was detained in a psychiatric hospital, and the judge ruled there that the parental authority was sufficient to consent him to be there, that because parents can typically determine what happens to their 15-year-old children, so the fact that they were approving it was okay as far as the judge was concerned. However, the case came back to court this year when D is now 16, and now he's in a residential care home. So he's out of the psychiatric hospital, but it's a care home that undeniably meets the acid test, high fences, locked doors, all that sort of thing. And this time the court judged, well, hang on, this cannot be consented to by parents because 16-year-olds fall under the Mental Capacity Act. They are deemed to be able to make their own decisions, and so parental authority is no longer sufficient for that consent. Okay, so he ruled that that this deprivation of liberty needs to be authorised, and that deprivation of liberty would need to be authorised by the Court of Protection because the safeguards do only kick in at 18. But this has implications for all of the various settings that you can see there, and potentially means yet again another big upturn in the cases going to the Court of Protection and cases going through the deprivation of liberty system, thus putting even more burden onto it. And it is that burden that I've mentioned probably far too many times over the course of the webinar that means that the system needs changing. And as a result of this, what happened after the Supreme Court judgment, the government asked the very brainy people at the Law Commission to come up with an alternative system. And what they came up with was an eye to the kind of harshness of the language that we talked about, was the much nicer sounding protective care system. Okay, and this essentially consisted in their very lengthy proposal of two elements: a supportive care element, which is basically just people keeping a more attentive eye on whether people are being restricted in their liberty, and a restrictive care element that more closely matches the deprivation of liberty safeguards that we have now, and that would have to be approved by a new role, an approved mental capacity practitioner. Okay. Crucially, this new protective care system they suggested should apply in all social care settings, getting rid of that slightly curious divide between care homes and supported living and shared lives and so on. But what it did do is then separate out hospitals and they proposed that for up to 28 days, a deprivation could be approved by one registered medical practitioner, and only after 28 days would the full approval process with the approved mental capacity practitioner kick in. Now, that was their proposal. It was lots of people commented on it and made lots of points, but the government's comment on it was that it's still too complicated and it's still too expensive, and can you go away and think again? And that's where we are now. So the Law Commission are going to have to use all their brains to come up with a system that is both straightforward and easy for people to use, but does preserve people's rights and people's protections. And I wish them luck with it. But you know, they're working on that now. But for now, DOLS is what we have, and DOLS is what we need to work with. Okay. So we're going to have a couple more questions, and then we're going to move on to some final few quiz questions at the end. Okay, so Helen, what have we got?
Yep, just a couple of quick ones. So if someone lives in a care home and doesn't feel safe going out on their own, and therefore has an escort, does that constitute a deprivation of liberty?
That's a really good question. I mean, I think because you might well have someone who lacks the capacity to consent to be in the care home, but does have the capacity to request company. Now, my sense would be that they are still under continuous supervision, and that probably would be a deprivation of liberty still, even though they were requesting it, because one's sort of happiness in adhering to a regime isn't to be factored into whether it's a deprivation of liberty. So that is a very good question, though, but that would be my best estimated answer at the moment, but I would have to look into that in a bit more detail.
And just generally a comment that we've had is that there needs to be more clarity on capacity, I think, in general, so people have kind of clear understanding at the outset around issues of capacity.
Yeah.
What that means.
I mean, I think, I mean, the rule, I mean, an awful lot changed when the Supreme Court made its judgment, but an awful lot didn't. And crucially, the mental capacity test of, does someone understand the information, can they retain it long enough to weigh it up and then communicate their decision? All of that still applies. And I think we, you know, and it also still applies that we only even assess someone's capacity if we've got reasonable belief that they lack it. So I think we are slightly, because we are so keen to not fall foul of the DOLS regime, I think there is a bit of a tendency to assume people lack capacity, and to start assessing their capacity when we don't really have good reason to. So I think people do need to be familiar with the assessments of capacity. And people need to have the confidence, though, to sometimes say, actually, we don't need to do one here, or having done one, say, actually, this person can consent to being here. And we need to remember, of course, that we need to have done everything we possibly can to, or practically can, to enable someone to make a capacitated decision about where they're living, you know, under the second principle of the Act. Okay, I can see that there's lots more questions, and we're slightly running out of time to answer them. So we're going to go on now to some quiz questions, because it's very hard for me to tell whether you've gone off and walked the dog, made a cup of tea, baked a cake over the last hour or so. Some quick questions now on just to, you know, round this off. Okay, so the first one is how many assessments, let's bring it up, there you go, how many assessments and how many assessors are involved in authorising a standard deprivation of liberty? Yay, 100% of you right, first time, brilliant. Excellent. Okay, second question. Person cannot be deprived of their liberty. In their own home. True or false? We're struggling to open this one up. We can't see the little box that tells us how to open the poll. Open. That's it. Here we go. Here we go. Yeah, there we go. Person cannot be deprived of their liberty in their own home. A good chunk of you have got that right. It is false. A person can be deprived of their liberty in their own home, albeit no one will probably thank you very much if you try to get it authorised by the Court of Protection. Okay, we're just going to close that one down and open up the next one. Where it says end poll. Sorry, I'm just giving. And the last one then. The focus of the Gilded Cage Supreme Court judgment was about the pressure on local authorities, the needs of care home providers, the universality of human rights, or the needs of small birds. Excellent. It is about the universality of human rights, and that, I suppose, is a suitable point to end it on. That is what the deprivation of liberty safeguards, for all their headaches they might be causing the social care sector and the healthcare sector. That is what they're about, and that is what we need to bear in mind. Okay. So we are ending now. I hope that was useful. If you want to know any more, Sky, and there's our website address, has a whole heap of information about the Mental Capacity Act in general and DOLS in particular. We've got social care films on the topic, a lot of written guidance, e-learning modules, and the MCA directory, which I really recommend as a sort of one-stop shop for good quality information and advice and resources on a whole range of different aspects, on all aspects of the Mental Capacity Act, including DOLS. If you want to know more on the Mental Capacity Act more generally, that there is a open training course in our Trafalgar Square offices on the 18th of May. That will be me running that training. Whether that puts you off or not, I don't know. But what you also need to know is that, unlike this, that is not free. That does come with a cost. But the booking details for that are all on our website. Okay. So as I say, thank you for sticking with me. I hope it's been useful. We will send out the transcript. I'm sorry, I'm conscious a lot of you were struggling to hear. I don't know what was going on with that, and there wasn't much we can do about it. Yes, we'll send out the transcript and the slides, and a recording of this will be available on our website. So if you couldn't hear it and you can bear it, you can sit there for an hour and watch the whole thing all over again. Okay, thank you, and we're going to sign off now. Cheers.